Welcome back to the deep dive. Today, we're plunging into a really fascinating area where, creativity, commerce, and the law all kind of meet.
Hmm,
Our focus is squarely on understanding who actually owns an invention, especially when that invention comes from someone who's also an employee.
that's right. It's a crucial overlap, isn't it? Intellectual property, contract law, employment law, it all comes together here.
Exactly.
And complicated.
It can be. And for this deep dive, our insights are drawn specifically from educational materials. These were made available by the University of London.
Yep.
We want to be really clear that our goal here is purely educational. We're just exploring the concepts, the key legal bits, and the important cases that are presented in these valuable learning resources.
Absolutely. Think of this as your guided tour through that material. And this deep dive is proudly brought to you by Sinorbit Academy, Sri Lanka.
Our mission today is to help you unpack the rules, explore those key cases we'll mention, highlight the really important facts, and, well, ultimately make sure you feel confident and ready to tackle this topic,
Yeah.
especially if you're prepping for an exam.
Yeah.
So, to all of you studying hard out there, good luck for the exam.
Yes, absolutely good luck. And to guide our exploration, we'll follow a pretty clear path based on how the materials are structured.
Okay.
We'll start with that fundamental question. Who does the law actually consider to be the inventor, in the first place?
Right.
Once we've got that pinned down, we'll delve into the special legal landscape for inventions made by employees. We'll look at how ownership is decided under that key piece of legislation, the Patents Act 1977.
Okay, the 77 Act.
Then we'll tackle the often tricky area of compensation for employee inventors. When can they get paid for their ideas even if the employer owns the patent?
That sounds important.
It is. And finally, we'll just round things off with a quick look at how patents can be dealt with commercially, as valuable pieces of property.
And as you said, the heart of this, much like the source material itself, is really going to be that Patents Act 1977.
Yes.
And the big impact it's had on the rights and sort of the position of the employee inventor.
Precisely.
Okay, let's jump right in that first fundamental question. Before ownership, we need the creator. So in patent law, who is the inventor?
Right. And this takes us straight to the Patents Act 1977. Section 7 of the Act is where you look.
Section 7, okay.
It says any person can apply for a patent, but, and this is critical, a patent can only actually be granted to the inventor or someone entitled through the inventor.
Okay. The grant goes to the inventor.
Yes. And the Act defines who that inventor is. That's in Section 7, subsection 3, Section 7.3.
Got it. Section 7.3.
It says the inventor, in relation to an invention, is the actual deviser of the invention.
Actual deviser. That sounds quite specific. What does that mean in practice? Is it the person with the initial idea, the eureka moment, or the one who, builds the thing? I understand this was a bit murky before the 1977 Act.
Exactly right. Before 77, the law wasn't nearly so clear. There was real uncertainty about whether inventorship rested with the person who conceived the underlying principle, the science bit,
Yeah.
or the person who actually made it work, reduced it to practice. But cases decided under Section 7 of the 1977 Act have really clarified this.
Okay, so the Act helped.
Definitely. The courts have firmly established that the inventor is the person or persons, it can be joint, who conceived or thought up the inventive concept.
Ah, the inventive concept.
Yes, the inventive concept underlying the patent. It's about the core novel idea, the innovative principle.
The inventive concepts. Okay, so that's the key phrase we need to remember for identifying the inventor.
It absolutely is. That focus on the inventive concept, that phrase, came through clearly in early cases applying Section 7.3, like Staying Ltd's application.
Staying Ltd's application.
Okay. That case, Staying, confirmed the court's focus should be on identifying who provided that core inventive concept. And this was reinforced later in other decisions, like Henry Brothers, Magerfeld, Ltd v. Ministry of Defense.
Henry Brothers, right.
Both Stang and Henry Brothers really solidified that it's the inventive concept that matters for inventorship.
The source material gives a really vivid example of this inventive concept idea. The cockroach trap case. That one definitely stuck with me.
Yes, IDA Ltd v. Southampton University. A great illustration.
IDA Ltd v. Southampton University.
Yeah. So the facts, basically, a professor at Southampton Uni published an article outlining his ideas for better cockroach traps.
Oh, yeah?
Then an employee from another company, IDA Ltd, called the professor. And during a confidential phone call, this employee suggested a crucial improvement, using magnetic powder in the trap.
So the professor had the general idea, but the IDA employee added the specific clever bit, the magnetic powder.
Precisely. And the court had to figure out, for inventorship and patent entitlement, who invented this improved trap with the powder.
Right.
And the court found that while the professor had the initial broad idea, it was the claimant's employee, the one from ID Ltd, who provided the critical inventive concept for the improvement being patented.
The specific inventive set.
Exactly, that innovative idea of using magnetic powder. So that employee was deemed the inventor, and his employer, IDA Ltd, got the patent rights.
Okay.
The IDA Ltd v. Southampton University case is a really clear example. It's the person providing the specific, novel, technical idea, that inventive concept, who counts as the inventor.
That makes sense. It's not just general background knowledge or saying, we need a better trap. It's providing the actual inventive solution.
Exactly. And this fundamental principle, identifying the inventor, has faced a really interesting modern challenge recently with AI.
Right. Artificial intelligence. Can a machine be an inventor?
Well, that was the question. This is the Thaler case mentioned in the materials, Thaler v. Comptroller General.
Ah, yes. Thaler v. Comptroller General.
Thaler v. Comptroller General of Patents, Designs, and Trademarks. This case directly tested the boundaries of that actual divisor definition in the age of AI. Dr. Stephen Thaler applied for patents, but he listed his AI machine, called Dabus, as the inventor.
He listed the machine.
Yes, as the sole inventor. The inventions themselves were apparently novel, patentable stuff, but the legal question was, could Davis be listed as the inventor under the Act?
And the answer was a pretty firm no, wasn't it? Across the board.
Correct. The UK Intellectual Property Office rejected it. Dr. Thaler appealed, went all the way up, High Court, Court of Appeal, and finally the Supreme Court. They all upheld the rejection.
All of them?
Yes. The Supreme Court decision was Thaler v. Controller 2023 UKSC 49. So High Court, Court of Appeal, Supreme Court in Thaler v. Controller 2023 UKSC 49. The finding was consistently against Dr. Thaler's claim.
What was the core legal reason they gave?
It boiled down to how they interpreted the Patents Act 1977 itself. The courts decided the language of the Act, especially Section 7.3, with its actual divisor wording, inherently requires the inventor to be a natural person.
A natural person, not a machine.
Exactly, a natural person. Repeat that. The inventor must be a natural person. A machine, like Dabus, isn't. And while Dr. Thaler's is a natural person, he didn't claim he invented it. He said the machine did.
Right.
Since the Act requires a natural person inventor, and Dabus isn't one, the applications had to fail.
So the law, written long before AI like this existed, just isn't set up to recognize a machine inventor.
That's the interpretation. Based on what divisor meant back then, a human, it really highlights how existing law grapples with new tech. Although the source materials note something interesting from the High Court stage of Thaler. The judge, Marcus Smith J., was careful. He said his decision was specific to the facts, and that the case did not require him to decide a different question.
Which was?
Which was whether the owner or controller of an AI machine that generates an invention could maybe, in some circumstances, be considered the inventor under the Act.
Ah, that's a crucial distinction. So the AI itself can't be the inventor, but maybe the human behind the AI could be in a future case.
That's the open question left by Thaler. The courts haven't ruled on that specific scenario. It's definitely one to watch as AI keeps developing.
Okay, so we know the inventor is the natural person with the inventive concept. What if people disagree about who that person was? How are disputes resolved?
Well, the Patents Act has mechanisms for that. For resolving disputes about inventorship and who's initially entitled to the patent, the UK Intellectual Property Office, the UKPU, they have jurisdiction to hear these disputes under Sections 8, 9, and 37 of the Act. Remember those? Sections 8, 9, and 37.
Got it. Sections 8, 9, and 37. And I think the materials mentioned some earlier confusion about what kind of dispute the UKPU could actually hear.
Yes, that's right, there was. For a while, the Court of Appeal had taken a view in cases like Markham v. Ziffer and even IDEA Ltd v. Southampton University that we just discussed, that for the UKPO to have jurisdiction under Section 37 about initial entitlement, there had to be some other underlying wrong, like a breach of confidence or breach of contract.
So the patent dispute couldn't stand alone. It had to be linked to something else.
That was the interpretation for a time, yes.
Right.
But it was definitively overruled by the House of Lords in the case of Yetta Research and Development Co. Ltd v. Rohnpool and Rohrer.
Okay, Yetta Research. That's the key one for clarification.
Yes. Yetta Research and Development Co. Ltd v. Rohnpool and Rohrer. The House of Lords in Yetta made it crystal clear. The only question the UK opinion to look at in an entitlement dispute under Section 37 is simply who came up with the inventive concept.
Just that.
Just that, whether it was one person or jointly. Things like breach of confidence or contract, those are separate legal matters. Yet research simplified it. The Section 37 question is purely about identifying the inventive concept.
That seems much more sensible. Keeps the focus on the invention itself.
It does. Isolates the inventorship question. Oh, and a related point from the source. If a patent is granted to the wrong person, that's actually a ground for revoking the patent later, under S.721b.
Then 721b.
But there are limits. Usually, only the true inventor or a co-inventor can bring that challenge, and there's a strict time limit, typically just 2 years from the grant date. So, S.721.
So if you think someone patented your invention, you need to act pretty quickly.
Precisely. Don't hang about.
Yeah.
And one final point on this. Even if the inventor doesn't end up owning the patent, which, as we'll see, is often the case for employees,
Right.
they still have a statutory right just to be mentioned as the inventor in the patent document. That recognition right is under Section 13 of the Act.
Yeah.
Section 13.
Right to get the credit, even if the ownership, goes elsewhere.
Yes, exactly. A right to recognition. So wrapping up this first section, the core concept is the inventor is the actual deviser of the inventive concept. They must be a natural person, Thaler. Disputes focus purely on who devised the concept, Jada. And this all sets the stage for the next big question, who actually owns that invention?
Okay, great. Moving from identifying the inventor to who owns it. And this is where it gets really critical for a lot of people because, as you said, the inventor is very often an employee. And this area saw a huge shift with the Patents Act 1977.
A fundamental change, yes.
Yeah.
Before the 77 Act, the law on ownership of employee inventions was entirely based on, well, judge-made case law, common law.
Right.
And that case law was heavily weighted towards employers, partly because of the idea of freedom of contract. Courts didn't like interfering, and partly just the reality of the economic power imbalance between employers and individual employees.
So how did employers typically stake their claim back then under the old rules?
The source materials highlight two main ways they did it. The first was simply through the employment contract.
Okay.
Employers would put in these really sweeping clauses, often called pre-assignment clauses. They were incredibly broad, basically saying any invention the employee made, maybe anytime, anywhere, belonged to the employer.
Wow, that sounds incredibly broad. Could employees challenge those?
They could sometimes, but it wasn't easy. A really significant case that did challenge one of these was Electrolux v. Hudson. You should remember that name. Electrolux v. Hudson.
Electrolux v. Hudson. Okay, tell us about that one.
So in Electrolux v. Hudson, the employee, Mr. Hudson, he was a storekeeper for Electrolux, the vacuum cleaner company.
A storekeeper, not an engineer.
Exactly, just a storekeeper. But he came up with some inventions for improving vacuum cleaners. His contract had one of those clauses saying he had to hand over all his inventions.
Right.
The court, specifically Falconer J., looked at this and said, hang on, for a storekeeper whose job isn't about inventing, this clause is too much. It's an unreasonable restriction on his ability to use his skills. It was found to be in restraint of trade.
Restraint of trade. Okay.
And because it was an unreasonable restraint, the clause was unenforceable. So, Mr. Hudson, the employee, got to keep the patent for his invention, not Electrolux. Electrolux v. Hudson was a key moment where a court said no to overly broad contracts, especially when inventing wasn't part of the job.
That's a powerful result for him in that situation. Okay, so contract was one route for employers. What was the second?
The second method was based on the idea of a trust. Sometimes courts would say the employee held the invention on trust for the employer.
A trust. How did that work?
Well, it typically happened in two main scenarios under the old case law. One was if the employee had what's called a fiduciary status.
Fiduciary status, like senior management.
Exactly. Senior people managing directors, maybe senior researchers, people in positions of high trust and responsibility. The court might infer that any invention they made as part of their senior role was automatically held on trust for the company. Cases like Worthington Pumping Engine Co. v. Moore and British Siphon Co. v. Homewood explored this for senior roles.
So their position itself created the obligation.
Kind of, yes. The other trust scenario was if the employee's contract or just the circumstances of their job showed they were specifically employed to invent.
Hired specifically to create new things.
Right. If your job was inventing, the court might easily say any invention you made was held on trust for the employer. That came up in cases like triplex safety glass, Covey-Scora. And of course, employers could draft contracts deliberately to make it look like someone was employed to invent.
So employers had these two strong routes,
Hmm.
sweeping contracts,
Yes.
though Electrolex showed limits,
Yes.
and this trust idea based on seniority or being hired to invent. And it sounds like fighting this was tough for employees back then.
It really was. The old 1949 Patents Act had a section, S56, that was supposed to help resolve disputes, but the House of Lords in Sterling Engineering v. Patchett
Drilling engineering feedback.
gave it a very narrow reading. The ruling in Sterling Engineering v. Patchett basically said if the employer already clearly owned the invention under those common law rules of contract or trust, then there wasn't really a dispute for the court to resolve under S.56 anyway.
That sounds like a catch-22. If the employer's claim was strong under the old rules, the supposed dispute mechanism couldn't even be used.
Exactly. It just reinforced the employer's strong position. So, summing up the pre-1977 situation, employers held most of the cards, very few successful challenges by employees, apart from that important exception, Electrolux v. Hudson, pushing back on those super broad contracts.
This picture of imbalance clearly needed sorting out.
It did. And this general feeling of unfairness, plus recommendations from important committees like the Banks Committee, a government white paper on patent reform, and also lobbying from trades unions,
Right.
all led to this completely new statutory framework for employee inventions in the Patents Act, 1977.
Okay, so what were the main changes the 1977 Act brought in? How did it shift the balance?
It brought three really major changes. First, it set up a new statutory test for ownership of employee inventions, a test written into the Act itself, designed to replace those old judge-made rules.
A statutory test.
Okay. Second, it introduced, for the very first time, a statutory scheme allowing employees to potentially get compensation for their valuable inventions, even if the employer owned the patent.
Compensation, right.
And third, crucially, it made certain types of contract terms unenforceable if they tried to reduce or take away an employee's rights under this new statutory system.
Those seem like really significant moves to help the employee.
They were intended to level the playing field. Definitely. Now, the absolute core provision for ownership under this new system is Section 39 of the Patents Act, 1977. Remember this number, Section 39, or S.39.
Section 39, got it.
It's central, and its importance is clear from the very start. It says it applies notwithstanding anything in any rule of law. That means S.39 overrides all that old common law we just talked about.
Okay, so S.39 is the starting point now for employee invention ownership. What's the basic rule in S.39?
Section 39 sets out the rules, and it actually starts with a default position. That's in S.39.
Section 39, subsection 2.
Yes. And it says, unless the invention falls into one of the specific circumstances in S.39, an invention made by an employee belongs to the employee.
Ah, so the default is employee ownership.
That's the starting point. The burden is then on the employer to show that the invention fits into one of the exceptions listed in S.39, which would give them ownership.
Okay, so employee owns it unless the employer proves it sits into S.391. What are those employer ownership categories in S.391?
Right. Section 39.1 gives two situations where the invention automatically belongs to the employer. They're listed as S.391A and S.391B. Here. Let's break down S.391A first. For the employer to own the invention under this part, two conditions both have to be met. They're cumulative.
Both conditions.
Yes. First, the invention must be made in the course of the employee's duties. These can be their normal duties or duties specifically assigned to them.
Made in the course of duties. Yeah.
Second, and this is the really crucial part, for A, the circumstances must be such that an invention might reasonably be expected to result from carrying out those duties.
Might reasonably be expected.
Yes, repeat that phrase. It's key for S.391. Might reasonably be expected to result from performing those duties.
So it's not just inventing at work. It's about whether inventing is something you'd reasonably expect to happen as part of that specific job.
Exactly right. This test in S.391 is basically asking, was the employee expected to invent as part of their role?
Expected to invent. Okay.
Is innovation, problem solving, developing new things within the reasonable scope and expectation of their job? Repeat.
Right.
Expected to invent. And we can see how courts applied this. Look at Wright Harris's patent. The employee was a salesman. He invented something.
Right.
The court applied S.39 and said, well, a salesman's duties don't reasonably expect inventions. His job is selling, not R&D. So under the default rule, S.39, the patent belonged to him, the employee.
Okay, Harris the salesman owned it.
Then there's Greater Glasgow Health Board's application. Here, a junior hospital doctor invented something.
A junior doctor.
Yeah. And even though they might do some research or teaching as part of training, the court found that generally a junior doctor's main job is clinical care. They weren't reasonably expected to invent, so again, the invention belonged to the employee doctor.
So for roles like salesman, junior doctor, even if they're clever, their core duties didn't hit that expected to invent bar in S.391.
Correct, based on how those roles were seen in those cases. But the source points out someone who wasn't originally hired to invent could move into a role or have their duties changed so that they do become expected to invent.
Ah, so it depends on the role at the time of invention.
Exactly. The court looks at all the circumstances when the invention was made. This came up in Liff Administration and Management v. Pinkava.
Liffey v. Pinkava.
Yeah. There, a change in the employee's role meant his later inventions did fall under X.391. Okay, now let's look at S.391. The other way the employer might own it.
Okay, the second limb.
This applies if the invention was made in the course of the employee's duties, same start as A, and D. When the invention was made, the nature of their responsibilities meant they were under a special obligation to further the interests of the employer's undertaking.
A special obligation.
Yes, repeat that. A special obligation to further the interests of the employer's undertaking.
That sounds different from expected to invent. Does it connect back to that old idea of fiduciary duty for senior staff?
It seems to capture some of that idea, yes, though the source says it's not a perfect match with the old common law trust ideas. The main case giving guidance on S.39 mentioned in the source is Stang Ltd's application again.
Sting again. Okay.
In Stang, the court suggested S.391B is likely aimed at senior employees, people like company directors or those with similar high-level responsibility and influence.
Right, the top brass.
Kind of. The court looks at everything, their pay, their position, all the circumstances, to see if there's a special obligation to look out for the company's interests, which might include developing or securing inventions. So while S.391A is about being directly expected to invent, S.39 Win seems more about a broader duty tied to senior responsibility to push the whole business forward.
Okay, so S.39 gives two roads for employer ownership.
Okay.
Either inventing is reasonably expected for the job, or the employee's senior role creates a special obligation. If neither fits, the employee owns it under the S.392 default.
That's the structure. And this is where Section 42 becomes absolutely crucial. Remember Section 42.
Section 42, the employee's shield.
Exactly. Section 42 says any term in an employment contract is unenforceable if it tries to diminish the employee's rights under the Act regarding inventions.
Diminish their rights.
Yes. This covers their rights under S.39 about ownership and also their potential rights to compensation under Sections 40 and 41, which we'll get to next. Repeat, S.42 makes diminishing terms unenforceable. So employers can't just write a contract saying we own all your inventions and you get zip. Section 42 would knock out any part of that clause that takes away the employee's statutory rights. It stops them contracting out of the 1977 rules.
That section is vital then. It stops us going back to the bad old days where contracts grabbed everything.
It's the statutory safeguard. So for your exam prep, really get your head around S.39. Understand the difference between 1A and 1B. Know what expected to invent and special obligation mean. And remember how cases like Harris, Greater Glasgow, Pinkava, and Stong show how these tests work. Applying S.39 to different job scenarios is key.
Let's try applying it with those scenarios from the source material. First up, a trainee solicitor working crazy hours invents a new energy drink. Who owns it?
Okay, trainee solicitor. Thinking about cases like Harris and Greater Glasgow, what are their duties? Legal work, right? Drafting, research, maybe court stuff. Inventing beverages, even if linked to work hours, isn't something you'd reasonably expect from their legal duties. So this looks like the S.392 default. The employee, the trainee, owns the patent.
Okay. Next, a university lecturer in sociology invents a new shampoo for head lice.
Sociology lecturer. Duties involve teaching and research in sociology. Inventing shampoos, chemical products, that's way outside their field and duties. Not reasonably expected at all. Again, S.392 default. The employee lecturer owns it.
Makes sense. How about a hairdresser's assistant who invents a brilliant new hair conditioner while on holiday?
The key here is while on holiday. That strongly suggests it wasn't made in the course of their employment duties.
Ah, the first condition for S.39 isn't met.
Exactly. Since it wasn't made in the course of employment, neither S.39A nor B can apply. Doesn't matter what their job is. So the employee owns it under S.392.
Right. Finally, a sales director for a washing machine company invents a new way to wash clothes using special detergent tablets in a bag.
Okay, sales director, that sounds senior. This points more towards S.39.
The special obligation one.
Potentially, yes. As a director, they have senior responsibilities to promote the company's business. If the company makes washing machines, or maybe detergents, inventing new washing methods could definitely be seen as furthering the employer's interests.
Hmm.
Their senior responsibilities might create that special obligation under S.39b. It's probably unlikely inventing is expected as a core duty for a sales director under A, but their overall duty to the company's success makes S.39b seem likely. So the employer probably owns this one under S.39b.
That really shows how you have to look at the specific role and circumstances for each limb of S.39. Applying those tests is the skill.
Absolutely. It always comes down to carefully looking at the employee's specific duties and responsibilities at the time they made the invention.
Okay, so we found the inventor, and using S.39, we've worked out who owns the patent, often the employer, if it fits S.391. Now, if the employer does own it, does the employee who had the bright idea get anything? The Act allows for compensation, but the source says it's been historically really hard to get.
That's right. The rules for employee compensation are in Sections 40 and 41 of the Patents Act, 1977. Remember those. Sections 40 and 41.
Sections 40 and 41 for compensation.
Yes. And historically, you're right, the conditions in these sections were interpreted very restrictively. The source even mentions that for many, many years, there was only one reported case where an employee actually succeeded in getting compensation under this scheme.
Just one. Wow, that really shows how high the bar was.
It does. Now, there are two main situations where an employee might be able to claim compensation under Section 40.
Okay, two rounds.
Circumstance 1 is covered by S.41. This is for when the invention belongs to the employer right from the start because of S.391.
Employer owns it via S.39.
Yes. And for a claim under S.401 to work, several conditions must all be met. They're cumulative.
All of them, okay.
First, the invention was made by the employee and belongs to the employer under S.391. Second, a patent must have actually been granted for that invention.
Patent granted? Crucial.
Absolutely. Third, the patent or the invention itself, or both, must be of outstanding benefit to the employer.
Outstanding benefit. That sounds like the tough one.
It was. And fourth, considering everything, it must be just that the employee should get some compensation.
Okay, 4 cumulative conditions. That second one, patent granted, seems like a potential early exit for the employer.
It really is. If the employer decides not to patent it, or the application fails, or the patent gets granted but then revoked before it makes money, no claim under S.4011. No granted patent, no S.401. Simple as that.
And that third one, outstanding benefit, that was the real historical hurdle.
That was the biggest problem, yes. The requirement for outstanding benefit in S.401 got a very narrow interpretation for years. The key word is outstanding, and it was judged relative to the size and success of the employer's entire business.
Ah, relative to the whole company.
Yes. The classic case showing this is British Steel Plex Patent. Remember that one? British Steel Plex Patent.
British Steel.
In that case, the employee's invention saved British Steel a lot of money, hundreds of thousands of pounds. Which sounds pretty good, right?
Yeah, substantial.
But the court said it was not outstanding benefit. Why? Because it was only 0.01% of British Steel's total turnover.
0.01%.
Yes, 0.01% of turnover was held not outstanding in British Steel. It showed how incredibly hard it was for inventors in huge companies to meet that test, even with valuable inventions.
That seems fundamentally difficult. A big saving is just swallowed up because the company is massive.
That's exactly the criticism. And other cases made it harder, too.
Yeah.
They suggested the benefit had to come mainly from the patent itself, not from other things like the employer's marketing muscle or existing customer base. For instance, in GEC Avionics Ltd's patent, success was tied heavily to a big contract the company won. The patent helped, but wasn't the only reason.
Okay.
And in Memco Med Ltd's patent, the benefit seemed more linked to long-term customer relationships than just the invention itself.
So the courts were isolating the patent's contribution and comparing it to the whole company. A double whammy.
That was the effect of those early interpretations, yes. Although the source does mention Entertainment UK Ltd's patent, which showed the benefit didn't necessarily have to take ages to appear. But still, the overall bar was incredibly high. But, as the source notes, there was one successful case reported before the big Supreme Court decision changed everything. That was Kelly and Chu v. GE Healthcare Ltd. Remember Kelly and Chu?
Kelly and Chu v. GE Healthcare, the first success.
The first one mentioned as successful before Shanks. It involved a really valuable patent for a radioactive agent used in medical imaging, worth about $50 million, they estimated.
$50 million.
Given that huge value, the court did find the benefit to GE Healthcare was outstanding, and the inventors, Kelly and Chu, got compensation. £1 million for Mr. Kelly, £500,000 for Mr. Chu, about 2% and 1% of the value.
Right.
So Kelly and Chu showed that with an exceptionally valuable patent, it was possible, but it was still very rare.
So Kelly and Chu was a positive sign, but that outstanding benefit test was still the main barrier until the Supreme Court got involved.
Precisely. And that brings us to the landmark decision. The real game changer for S.40 compensation. Shanks v. Unilever SSE. You absolutely need to know Shanks v. Unilever.
Shanks v. Unilever, the big one.
Yes. It went all the way to the Supreme Court in 2019 UKSC 45. And the court specifically looked again at sections 40 and 41, especially at the meaning of outstanding benefit. Repeat. Shanks v. Unilever Parisi, Supreme Court, 2019 UKSC 45.
So what was the crucial change or clarification the Supreme Court made in Shanks?
The Supreme Court, led by Lord Kitchen, revisited outstanding. They agreed it means exceptional or such as to stand out, but the really key clarification was how you assess that benefit, especially in big group companies like Unilever.
Okay.
The Supreme Court said the lower courts had got it wrong in cases like British Steel. They were wrong to compare the patent's benefit to the entire turnover or profit of the massive global group the employee worked for.
So what should they compare it to?
Instead, the Supreme Court in Shanks ruled, you should compare the benefit to the part of the group specifically concerned with the inventive activity.
Compare it to the relevant part of the business.
Exactly. Repeat this key point from Shanks. Compare the benefit to the part of the group concerned with inventive activity, not the whole group. That's a massive shift.
Wow, that completely changes the comparison point. A benefit that looks tiny against a global giant might look huge compared to just the R&D division or the unit dealing with that tech.
Precisely. That's the core impact of Shanks. And applying this new, more focused comparison, the Supreme Court found that the benefit Unilever got from Professor Shanks' patents was outstanding.
They found it was outstanding in Shanks.
Yes. They gave specific reasons. The rewards were substantial, clearly significant. Unilever got them with little risk. It was a very high rate of return. The benefit stood out compared to Unilever's other patents, and crucially, the benefit came directly from the patents, not just Unilever size or market power.
So they tackled both the relative to the whole company issue and the must flow mainly from the patent issue.
Yes, by refocusing the comparison and looking at the patent's direct contribution within the relevant business context. The Supreme Court in Shanks also said you should factor in the time value of money, the fact the employer had the benefit for years before paying compensation.
Right. And what about the actual amount, the fair share?
Good question. Having found the benefit outstanding, they looked at Professor Shanks' fair share under S.411. The original hearing officer had suggested 5% might be appropriate if the benefit was outstanding. The Supreme Court agreed with this, mentioning 5% as a fair share in this case.
And the final award for Professor Shanks?
Based on the benefit and that 5% share, Professor Shanks was awarded £2 million. Repeat. Professor Shanks got £2 million in Shanks v. Unilever.
£2 million? That's huge.
A very significant result. It showed successful claims are now genuinely achievable, although it still depends on the facts, the financial benefits, and the context of the employer's inventive work. The Shanks decision gives a much clearer and arguably fairer way to assess outstanding benefit under S40. It makes the compensation scheme potentially more accessible, even in large companies, if the invention brings significant value relative to the relevant part of the business.
That's a really important development. Okay, so that's S.40. Employer owns it from the start. What about the second circumstance for compensation under S41?
Circumstance 2 is covered in S.40 too. This applies where the invention initially belonged to the employee because it didn't meet the S.39 test, so it was theirs under S.39 in test.
Employee owned it first under S.392. Okay.
Right. The conditions for a claim under S.402 are, first, a patent must have been granted for that employee-owned invention.
Patent granted again.
Still need that, yes. Second, the employee must have later assigned, sold the patent, or granted an exclusive license to their employer or an associated company.
Assigned or exclusively license it to the employer.
Yes. Third, the benefit the employee got from that deal is found to be inadequate compared to the benefit the employer later derived from the patent,
Inadequate benefit to the employee.
compared to the employer's benefit. And fourth, again, it must be just that the employee should get additional compensation.
So this is for when the employee owned it, did a deal, but the deal turned out to be poor value given how well the patent did for the employer later.
Exactly. The source notes limitations again. No patent granted. Or if the employee only granted a non-exclusive license, meaning they could still license others. No claim under S.4 Dauber. And that term inadequate benefit in S.402, it raises similar evaluation issues to outstanding benefit in S.421. It's likely the Shanks guidance on assessing the employer's benefit would also be helpful here when considering inadequacy. Section 41 then lists factors for the court to consider when calculating a fair share under either S.401 or 2, things like the employee's duties, effort, employer's contribution, etc. But as the source points out, and as that long history before Shanks showed, the real fight was usually just meeting the S40 conditions in the first place, especially outstanding benefit under S.401. It makes you ask, doesn't it? How effective has this scheme really been overall? What is a fair share? Shanks definitely helped, but these questions about the scheme's impact still linger.
Okay. Connecting back to studies. Understand SS.4 and 41. Know the different conditions for S.401 and S.402. Remember the history, the struggle with outstanding benefit, British Steel, the rare early success, Kelly and Chu, and critically, the Shanks v. Unilever case that redefined the test. And remember, all the conditions in S.40 are cumulative. Right, let's look at those compensation scenarios from the source applying these rules. Scenario 1. Employer refuses to apply for a patent. Too expensive.
Okay, key condition for both S.401 and 2 is...
Patent granted.
Exactly. If the employer refuses to apply, no patent is granted, so the employee simply cannot claim compensation under S.40 as it's written. End of story for that route.
Okay, scenario 2. Employer points to a collective agreement with the union. It sets compensation for inventions at, say, £2.50 flat.
This brings Section 42 right back in. Remember S.4.
To shield. Knocks out terms that diminish employee rights.
Precisely. If that collective agreement term fixing pay at £2.50 diminishes the employee's potential rights under the Act, which include possibly much higher compensation under S.40 if the conditions are met.
Yeah.
Then S.42 makes that term unenforceable. The employee isn't bound by the £2.50. They could still try to bring a claim under S.40, arguing the collective agreement term is invalid thanks to S.42.
So S.42 protects against collective agreements too, not just individual contracts.
Seems so if they diminish the statutory rights. It's broad. Okay, scenario 3. Employment contract has a standard term. Says all inventions during work hours belong to employer and employee gets no compensation. Another direct hit for S.42. That no compensation part directly diminishes the employee's potential right to compensation under S.40 if the invention belongs to the employer under S.39 and meets the tests. So the no compensation bit is unenforceable under S.42. The employee could still potentially claim under S.40 if the invention meets all the S.40 conditions regardless of that contract term.
Got it. Scenario 4. Employer closes the company, sells the patent cheap to a new company they set up. Employee made redundant.
Oof, tricky one. The source implies this is complex. If the original employer got outstanding benefit before shutting down or doing the cheap sale, maybe a claim against the old company is possible. But chasing a dissolved company is hard. Claiming against the new company depends if it's legally associated with the old one and if it is now getting outstanding benefit. Very fact-dependent. Likely very difficult legally.
Okay. Last one, scenario 5. Patented invention wins a big industry prize, but profits are low due to market conditions.
Right. Section 40 needs outstanding benefit to the employer. Courts have always read benefit mainly as financial or economic benefit.
Money, basically.
Pretty much. Winning a prize is great, good PR maybe, but it's generally not the kind of financial benefit S.40 requires.
Right.
Low profits mean low financial benefit. Even after Shanks clarified how to assess benefit, you still need a significant financial benefit to start with. A prize alone, without the cash flow, is very unlikely to meet the outstanding benefit test.
Okay, that makes sense.
So always remember Section 42. That's the key protection for employees against contracts trying to take away their statutory rights under SS.39, 40, and 41.
That's a really thorough look at compensation. Okay, finally, just for context, how do patents actually work commercially? Buying, selling, licensing?
Yeah, this section is background, but it helps frame why we care about the benefit for compensation claims. Patents are legally classed as personal property. That's under Section 30 of the Act. Repeat. Patents are personal property under S.3.
Section 30, personal property, like owning a car.
Sort of, yes.
Yeah,
It means they can be treated like other assets. They can be assigned, sold, or transferred or licensed. Any deals affecting ownership, like assignments, must be in writing.
must be written down. Okay.
And it's really important that these dealings get recorded. The UKPO keeps a register of patents that's governed by Section 32. Repeat, the Register of Patents, S.32.
Section 32, register. Why is registration so important?
It's especially crucial for people who get licenses. You can license a patent, give someone permission to use it. It can be non-exclusive, lots of people can get a license, or exclusive, only the licensee and maybe the owner can use it.
Right.
Now, an exclusive licensee has legal standing. They can sue for infringement along with the owner under Section 67, repeat, S.67.
Section 67, exclusive licensee rights.
But under Section 68, if that exclusive license isn't registered within a certain time, the licensee can't get their legal costs back if they sue for infringement. Repeat, S.68, costs penalty for non-registration.
Ah, so if you're an exclusive licensee, you absolutely must register it quickly to protect yourself if you need to sue later.
Exactly, very practical consequence. Registration is vital for exclusive licensees.
Okay. Are there other ways patents get used or accessed beyond standard sales and licenses?
Yes, the source mentions a few other mechanisms, often for public interest reasons or to make sure inventions get used.
Like what?
Compulsory licenses, that's under Section 48, repeat. Compulsory licenses, S.48. If 3 years after a patent is granted, the owner hasn't really exploited the invention, the UKPO can force them to grant licenses to others. Stops people just sitting on patents to block competition.
Okay, Section 48. Force them to license it out.
Then there are licenses of right, Section 46, repeat, licenses of right, S.46. This is voluntary. The patent owner asks the UKPO to mark the patent licenses of right available. It signals they're happy to grant non-exclusive licenses to anyone who asks. Renewal fees are lower, too. If you can't agree terms, the UKPO can set them.
Section 46.
Okay.
Advertising willingness to license.
And finally, Crown Powers, Section 55, repeat, Crown Powers, S.55. The UK government has special powers to use patented inventions for public services, sometimes even without the owner's full agreement, though they usually pay compensation.
Section 55. Government use. Got it.
And one last crucial point. All these commercial dealings, especially licenses, have to comply with competition law.
Ah, competition law.
Yes. Both UK law, the Competition Act 1998, and EU law, like Articles 101 and 102 TFEU, which deal with anti-competitive agreements and abusing market dominance.
Right?
There are specific rules, like the Technology Transfer Block Exemption Regulation, that's EC No. 772/2004, which basically give a green light to certain types of tech licenses as long as they don't have really restrictive clauses. Repeat, Competition Act 1998, Articles 101-002 TFEU, and the Technology Transfer Block Exemption Reg.
So patents are valuable property, lots of rules around transferring and licensing them, and they operate within competition law too.
Exactly. And understanding this commercial side, even just as background, helps you see how an employer gets that benefit from a patent, the benefit that's so crucial for employee compensation claims under Section 40. It comes from using, selling, or licensing that valuable property.
Wow, okay. We've really covered a huge amount of ground in this deep dive. We started with the inventor, the actual deviser of the inventive concept, who must be a natural person, told her with disputes focusing just on the concept yada.
Yep.
Then we dove into the crucial rules for employee ownership under Section 39 of the 77 Act. Replacing the old law, setting up that test based on being expected to invent. Remember Harris, Greater, Glasgow, Pinkafa, or having that special obligation, think Stang.
Yeah, and then into that whole complex area of compensation, Sections 40 and 41. We saw the historical difficulty with outstanding benefit under S.401, British Steel, Memco Med, then the glimmer of hope with Kelly and Chu.
Right.
And crucially, how the Supreme Court in Shanks v. Unilever really clarified and arguably lowered that bar by changing the comparison point, leading to that big £2 million award. We also touched on his point 402 for employee-owned inventions transferred later, and how Section 42 protects employees from unfair contract terms trying to cut down their rights.
And finally, we looked at patents as personal property. The register is 32, why registration matters for exclusive licensees, Deficit 768. Other exploitation routes like compulsory licenses, Deficit 48, licenses of right, S46, Crown Powers, PITS 55, and the competition law context. Remembering those key cases, Sang, IDA, Thaler, Yeda, Electrolux, Harris, Greater Glasgow, Pinkava, British Steel, Kelly and Chu, and especially Shanks, and knowing those key sections, 13, 30, 32, 39, 40, 41, 42, 46, 46, 48, 55, 67, 68, plus the competition stuff,
Mm-hmm.
along with those core concepts. Inventive concept, actual deviser, natural person expected to invent, special obligation, outstanding benefit, inadequate benefit, and that vital role of Section 42. That should really help cement things for your exam studies.
Absolutely. And reflecting on all this material,
Yeah.
the history leading to the 77 Act and the decades it took before Shanks really made the compensation scheme seem workable, it does raise an interesting question, doesn't it, for you to think about?
Yeah.
Even with the Shanks clarification, has the law truly found the right balance now between, employers getting the inventions made in their business and employees getting a genuinely fair reward when their ideas create massive value? Or is that outstanding benefit hurdle, even post-Shanks, still so high that many valuable employee inventions effectively go unrewarded beyond salary?
Hmm. A really interesting thought to ponder as you continue your preparations. That brings this deep dive to a close. We really hope this exploration has been incredibly helpful for you.
Yes, good luck for all of you for the exam.
Until the next deep dive.